Mr. Bob, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 24th, 2025 at 10:13 p.m., officers were dispatched to a major crash on Irving Boulevard in Harris County, Texas. The defendant ran a red light and another vehicle struck the back left rear of his vehicle, and officers arrived on scene and saw the defendant sitting in the driver's seat with keys in his pocket and the engine running. The officer observed the defendant to be unsteady on his feet with an odor of an alcoholic beverage. The officer then observed the defendant to be unsteady on his feet and needing help walking at times. Furthermore, they observed red glossy eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant stated he was coming from a club and was heading home. The defendant stated he had 3 to 4 drinks, and standard field sobriety were then conducted. HGM 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. A search was conducted on the defendant's vehicle, and the officers found a 1/5 full bottle of whiskey in the passenger seat in a bag, and the defendant consented to breath, and the result.
Well, not only was the bottle still in the passenger seat, but his breath test came back at 175. That's over twice the legal limit. For context, that's not just tips legally obliterated. And since this is his second offense, that ignition interlock the judge mentions next. Yeah, it's basically a breathalyzer built into your car, just so you can prove you're sober enough to start it.
0.175 and 0.162.
Are you telling me that he's consuming alcohol allegedly while driving?
There's no indication of being cold to the touch or anything, just 1/5 full on the passenger seat.
What was it?
A bottle of whiskey.
Right. Mr. Bob, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please?
It's eligible, Your Honor.
I'm ordering you as a condition of your bond and not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming illegal drugs or any kind of alcohol, I will put you in jail. Because it's a second offense, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to put you in jail. Do you understand? I'm sending notice to DPS in Austin where every single officer now knows that any vehicle that you drive is required to have an interlock. So if you're pulled over and it doesn't have an interlock on it, then they're going to take you to jail. Do you understand? Okay. Please, yes. I'm sorry? 7.
My counsel didn't show up. I don't know.
You have a lawyer?
Yeah, I do, but he didn't show up. George Powell.
Oh, well, let's do this. I didn't realize it. So let's do this. I'll have you sign a reset. We'll have you get with Creechall for your bunk innocence. Just hang tight. He'll be here. I mean, we start early and I don't know. Don't fret. I'm sure that he's on the way. Okay. I know George. He's a good guy. We'll just have you take a seat after you sign both your conditions and then we'll wait for him to come. Okay? Please. All right, Mr. Diaz, I don't know why we have you in custody. Well, I'll tell you now.
Yes, sir.
You, with us, have picked up a possession of a controlled substance. You are facing up to a year in jail and or a $4,000 fine. What I see is that you are now also on felony probation for possession of a controlled substance. It looks like they've issued a warrant. You're set at no bond on that case. So we have to take you into custody. I can't let you go with a felony warrant. So what'll happen is you will probably roll up on Monday's docket in felony court. And then, assuming you have a lawyer, they'll help you out upstairs. So regardless, we're going to do probable cause in our case. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I will also appoint you a lawyer this morning.
Yes, sir. I just got done talking to he's on his way actually.
Who's your lawyer?
Robert Reyes. I just got done here talking to him before he pulled me in the room.
Okay, we're going to do probable cause and then I'll just have you in back. When we get to any issues, we can always talk.
Yes, sir. Thank you.
Please.
Yes, Judge. On January 25th, 2025, at approximately 1:18 p.m., the officer was dispatched to Katy City Park in Harris County, Texas, in regards to a male drinking in public. Dispatch notes described a Hispanic male wearing black pants and a black and gold jacket. Upon arrival, the officers observed a person matching that description walking away from a field where the suspect was reported being suspicious. The officers met with a witness who observed the defendant walking towards the parking lot and west of the field, and then the officer made contact with the defendant and observed him appearing intoxicated. slurred speech, incoherent speech, unsteady without the ability to stand, and the defendant was detained, and the defendant was
Okay, pause. The pills were hidden in an amoxicillin, but Liso, not your average pharmacy trip. But notice how fast the defense lawyer jumps on the walking while Hispanic comment. That's a real issue in some courts. Profiling and probable cause go hand in hand. What do you think, chat? Was this a justified stop or a stretch?
made demands ensuring the officer of street accreditations, and a pat down was then conducted. The defendant was in possession of an amoxicillin bottle with the defendant's name on it. The bottle contained illegal contents. In the bottle was a pinkish, orangey, unknown pill and a white pill. The white pill was recognized from training experience as Xanax with a weight of 0.29 grams.
What's he doing? Walking while Hispanic? You know?
What?
Really?
Your Honor, there was a report of a person drinking in public, and then there was a witness who saw him walking to the parking lot, and then they gave a description, and he matched that description.
Let's do this. I'm not ready to rule on your case. Let's wait for your lawyer to get here. I'm going to have him look at everything, and then we'll go from there. Do you mind?
All right.
Okay. You got it, man. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are roommates. On January 25th, 2025, the officers were dispatched to a disturbance call. Upon arrival, the officer met with the complainant, who stated that she and the defendants are roommates and that the defendant was crouching down with his phone when she touched his phone to indicate for him to move. The defendant then struck her in the face with a closed fist, causing pain and a small cut to her lip. The officer then observed a small cut to the complainant's lip.
Sir, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you violate this protective order, they can file additional charges against you. A violation of protective order is one of the worst cases you can pick up. Do we know if she wants to have contact with him, Alex?
He attempted to reach out, but no success.
Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. You're not to be in possession of weapons as well. Do you understand? If you violate these conditions, I'm going to issue a warrant for your arrest. I'm going to put you in jail. No more PR bonds. Would you like a lawyer, sir? I need you to fill out an application for me. I'll have you talk to someone today. I'm going to have bond conditions created for you to sign. Do not leave until you sign the bond conditions. Otherwise, I'm going to issue a warrant for arrest. We'll provide you a lawyer today. All right? Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer conducted a motor vehicle check on the defendant's vehicle while traveling on the 7500 block of West 1960 Road in Harris County, Texas. The officer observed the registration to be expired as of January 2024 and no valid financial responsibility on the vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The officer conducted a person check on the defendant and saw her driver's license was suspended as of February 1st, 2024, and she was identified with a Texas ID.
All right, Miss Orange, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance. But if I find that you drive, it's going to go really, really wrong between us. Do you understand? I'm going to have you sign an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care if there's a burning building with 50 kittens that need to be saved. Do not drive. Do you understand? I'm giving you now the number to the driver's license division to DPS. This is the number that you need to call to figure out what you need to do to get your license back. When you call them, call at 7 in the morning. Do not call at 8:01. Do not call at 9:50, 1:03. You'll never get through because the lines are so jam-packed. You need to call the minute the phone lines open up, which is at 7 in the morning. They can tell you what you need to do to get your license back. If you get it back and you show me that you also have insurance, I will take this restriction off of you. Trust me, do not drive. Do you understand?
Yes.
You need a lawyer to represent you in this case. Would you like me to give you a court-appointed lawyer? Okay. I will give you one. I need you to fill out an application for me. I'm gonna have you swear to us that you're not gonna drive. After that, I'll get you to Victoria, sign a reset, and then we'll have you take a seat in the jury box where we find your lawyer. Okay? Please. You are Ms. Patterson?
Yes, sir.
And you are charged with criminal trespass of a habitation or shelter. As such, it's kicked up to a Class A misdemeanor. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer was dispatched to an apartment regarding a family disturbance. The officer made contact with the complainant, and the complainant was in a former dating relationship with the defendant and stated the defendant had been banging on the door of her apartment since January 23rd, 2025. The defendant had not made any threats or said anything besides banging on the front door. The officer observed the defendant moving around the rear seats of the complainant's motor vehicle, and the complainant approached the vehicle and claimed ownership and identified the defendant as the person inside. The complainant stated she recently got the vehicle, had not let the defendant borrow the vehicle or use it in any manner. The complainant also stated she secured all the seats, and the defendant stated the motor vehicle was already unlocked and the officer did not observe any signs of forced entry. So in this case, the trespasses of the vehicle. And that is how the information is pled as well, Your Honor.
I don't know if that counts as a habitation,
And Your
shelter, super fund,
Your Honor,
car.
as the information reflects, the charge is just criminal trespass with the vehicle being alleged to be the trespass. There's no mention of a
I
habitation.
get it, but you picked it up. Like if it was a Class B, okay. But in this case, the intake made it a Class A by saying it's, typically this enhancement is reserved for a structure, right? Like a house, an apartment, a shelter. I don't know if a car counts. Let's look it up. Yep, it includes vehicle. Habitation means a structure or a vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle, and each structure appertaining to or connected with the structure or vehicle. Vehicle includes any device in, on, or by which any person or property is or may be propelled, moved, or drawn in the normal course of commerce or transportation, except such devices as are classified as habitation. Okay, all right. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to go where they live. Do you understand? The complaining witness in this case.
That's where I live. And they here today.
This, I'm going to appoint you a lawyer today.
Okay.
We'll have you guys work out the kinks. The only thing I want is I don't want you to have contact with the complaining witness in this case, no weapons, and not to go where they live or where they work. Do you understand? Unless I know that they want to have contact with you. So we're going to find out. Have you done a RIP?
No, Your Honor, we haven't had a chance to. We can reach out now, see.
So we're going to need a little bit of time.
She's
Here,
here.
Your Honor.
So let's do this. Let me appoint your lawyer now.
Okay.
She's back there in the head. Okay, we'll have you guys talk, but for the meantime, I'm going to have you sign a receipt at Victoria. We'll have you take your seat in the jury box, okay? Please. Ms. Pena, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer observed the defendant's vehicle in front, following a vehicle very closely at the 2800 block of Center Street in Harris County, Texas. An NCIC search showed an unconfirmed insurance status with no match found within the last 45 days. The traffic stop was then conducted, and the officer made contact with the defendant, the driver of the vehicle, and the officer observed red bloodshot eyes, strong odor of an alcoholic beverage, and the defendant stated she got off work, smoked marijuana, and went to a local bar where she had one beer. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated her level of intoxication would rank 4 on a scale of 1 to 10, and the defendant was read the DIC, and she consented to breath. The results were 0.053 and 0.056. The defendant then refused a DRE evaluation and a consensual blood draw was completed.
Okay. So how many other DWIs does she have?
It was just one prior in 2022, Your Honor.
NCIC?
I ran it, Your Honor. There's only the one prior.
The other PCS that was right afterwards, right? Oh, so they were both, okay.
They were both dismissed, Your Honor.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Oh, have you run her license?
It's eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything, I'm going to revoke your bond, put you in jail. Do you understand? Do you need a lawyer today, ma'am? Okay, I'll have you fill out an application. I'll take a look at it and see whether you qualify, and I'll appoint your lawyer today. If you don't have a license, don't drive. If you don't have insurance, don't drive. Above all else, don't consume alcohol or illegal drugs. You understand? Okay, please.
Good morning. Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 25th, 2025, the officer arrived on scene and made contact with another officer who had been en route to a burglary and observed the defendant's vehicle traveling in the middle of a two-way road. That officer had pulled over to the right as far as possible, slowed down, and the defendant still struck the patrol vehicle on the front left side. The officer stated that the motor vehicle continued to drive, turned into an apartment complex, and the officer pulled up behind the vehicle as it was waiting for the gate to open. The defendant exited the vehicle, and the officer made contact with the defendant. The defendant stated he did not know who he had struck, and the officer observed red glossy eyes, slurred speech, a strong odor of an alcoholic beverage. Standard field sobriety tests were administered. HGN, 6 out of 6. Walk and turn, 5 out of 8. One leg stand, 2 out of 4. The defendant read the DIC and considered a breath. The results were .141 and .145.
Mr. Orion, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, you will go to jail. No more PR bonds for you.
And there's no license on file, Your Honor.
Right, to be honest.
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, Mr. Oriana, you are not allowed to drive. You will be signing a promise with me today. I hope you take this seriously. This is the only warning that you will get. I don't know what your immigration status in this country is, but if you're not in this country with permission and you go to jail for any kind of any kind of period of time, it's very possible that immigration finds you, puts a detainer on you, and you will be stuck in custody until this case is over with, and then you will be shipped off to immigration. Do you understand? Do not drive, do not consume alcohol or illegal drugs. Otherwise, it's not going to end well for you.
No le va a ir bien a usted. Gracias. Thank you.
Tell me, did you want to apply for a court appointed lawyer?
Quiere solicitar un abogado de planta.
Sí.
Yes.
All right, I will give you an
Le voy a dar
application.
una aplicación.
I will take a look at it,
Entonces la
see
miro.
whether you
A
qualify
ver si
for
usted
a.
cualifica para un abogado.
I'm gonna have you come up here, swear to us that you're not gonna drive. I will get you to Victoria where you will sign a reset. You will then get with Fatima for your bond conditions, and after that, we'll have you take a seat in the jury box, sir. Mr. Alfaro, you are charged with harassing communication. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On August 26, 2022, the officer was dispatched to a harassment call and met with the complainant, who explained she had broken up with the defendant on August 20th after dating 2.5 years. The defendant came to the complainant's parents' home early in the morning of August 21st and began knocking on the door and refused to leave. The defendant got into an altercation with the complainant's brother, and the complainant then went to work where she received phone calls and text messages. The complainant responded in text asking for the defendant to stop contacting her, and over the next 2 days, the defendant continued to text the complainant asking to just talk. On August 24th, the complainant went to the defendant's apartment to retrieve her belongings, and upon returning to her parents' house, the complainant observed the defendant circle the area. On August 25th, the complainant's father observed the defendant parked down the street in the vehicle. 5 p.m. that day, the complainant's friend observed the defendant had been driving past the complainant's apartment, and the complainant observed the defendant driving around her parents' neighborhood and parked outside for a while before leaving. The defendant then attempted to contact the complainant by phone and text messages, as well as driving to the complainant's place of work and contacted the complainant's work asking to speak with the complainant. The complainant stated she has received 50 calls and approximately 100 text messages, as well as 15 to 20 calls from some unknown number.
So far, I'm going to find that there's probable cause to go forward into your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? I don't care what you're doing. I don't care where you're going. I don't care what color you are. If I find that you try to have any kind of contact, I'm going to put you in jail. Do you understand? How old are you, sir?
25.
Did you want to apply for an appointed lawyer, sir? Okay. Can you file the conditions, no contact and no weapons, please? I'm going to give you an application now. I'm going to have you sign a reset with Victoria, then we'll have you take a seat in the jury box. I'm going to find your lawyer. Do not leave until you sign our bond conditions. Do you understand? Okay, please.
So I'm one of your MAC attorneys today, Judge, and I have a couple clients, but Miss Patterson, she's
Yes.
struggling. It's a trespassing case,
Okay.
and it's a little weird, but I think you might have issued conditions for no contact at all.
Okay.
And we were going to ask if the state was in agreement to change that to no threatening, harassing, assaultive contact.
So my thing is that I always want to honor the the wishes of the complaining witness. If they're okay with it, then I'm okay with it.
I spoke with the complainant and she's fine with them living together and still contact. It's just no threatening, harassment being
Where is Miss Patterson? Come up, Miss Patterson. So, got it, yeah. So I will amend your conditions to order you not to have any threatening or harassing contact. What you need to understand, what is threatening or harassing doesn't matter what you think. It's what she perceives. So is this threatening or harassing? It most certainly is, and it can land you in jail. So I don't know what kind of relationship you have, but if it's one that you're constantly butting heads, be careful, because you're the one that's going to end up in jail if there's another fight and she comes up and she starts complaining. Do you understand?
Yes, sir.
Okay, it's done. All right, so you file it, we'll sign it, and then you guys are free to go. And one more thing, you must stay in touch with Mr. Landreneau.
Yes.
If he tells me he can't get a hold of you because you've gone AWOL, I'm going to issue a warrant for your arrest. Don't pick up a new case. Okay, good luck. Mr. Martinez, you are charged with evading arrest, theft, failure to identify oneself, driving while intoxicated, and you also have a felony theft of a firearm. What are we doing?
He is pleading guilty to the DWI and the evading, 30, credit for 23, and then they are going to dismiss the felony. That's why Herman's here. He's on the felony.
So, well, they're going to dismiss what, the felony
Once
theft?
he pleads, they're going to dismiss the felony, yes.
So we're going forward on the DWI and the evading.
Yes, Your Honor, that is correct.
Mr. Martinez, you're charged with driving while intoxicated and evading arrest. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On the evading arrest, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 23 days. He actually has 26 days credit.
And that right, there is Judge Fleischer doing what he does best, dropping the gavel reality. Martinez just pled to multiple charges. But here's the kicker. Even though one case is dismissed, it'll still show up on his record. No clean slate. This is a kind of courtroom moment that shows how one bad night can follow you for years. What would you do differently if you were in his shoes?
23.
Okay. You need to understand that these charges will go on your record. The evading arrest is an enhanceable offense. If you ever run from the cops again, you will be charged with a felony offense. Do you understand?
Yes, sir.
The DWI is also going on in your record as well. So if you ever get pulled over by an officer, they're going to look up your record. They're going to see, man, this guy's got a lot of baggage on his record. If they smell alcohol or if they smell dope on you, what do you think they're going to do?
I already know it. They're gonna pick me up.
From now on, you are facing a minimum of 90 days in jail. Any new cases that you pick up. Do you understand?
Yes, sir.
Even if you've had a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk.
Sir.
You understand?
More drugs. More
Anything.
drugs.
What I informed Mr. Martinez,
Okay, any
for your
drugs, sir.
purposes, even though he's getting his theft dismissed, it's gonna be based on a conviction on another case, so it's not expungable. The statute does not allow that case to be expunged,
Which one?
the theft of a firearm.
You understand that, right?
Yes, sir.
I don't think any of the cases. Or wait a second, hold on a second.
Separate, the ones that are separate transactions, Your Honor.
All three are out of the same transaction.
Okay, well then, yeah.
Yeah, so the evading, theft, failure to ID, all those are based out of the same transaction because none of the cases can be expunged. So the ones that are dismissed, they're going to stay on there, they'll be dismissed, but the others will reflect as a conviction on your record. That's what I'm saying. From now on, it's a minimum of 90 days in jail for anything that you pick up here in misdemeanor court. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Do you understand?
Yes, sir.
This is what you want to do. How do you plead to both of the cases, guilty or not guilty?
Good, sir.
I want you to understand one more thing, Mr. Martinez, that DWI is big business in Harris County. There's a $3,000 surcharge that normally would apply to this. I'm not going to stick it on you now because it's a first offense, but on a second DWI, you're looking at a $6,000 surcharge that you get hit on a second DWI. Get a clue, take an Uber. Do you understand?
Yes, sir.
I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir.
Thank you, Your Honor.
Thank you, sir.